at home where he's supposed to be the entire time. I'm going to respectfully ask the court to consider, I know we can't reinstate his bond, it's already been forfeited, but if the court would consider a monetary bond, a reasonable monetary bond in this case, and or an OR bond with whatever other restrictions the court would deem necessary to ensure his appearance. I'm sure Mr. Cochran will appear. He's eager to resolve this matter. Thank you, Your Honor.
Thank you, Ms. Cutts.
Thank you, Your Honor. The defendant was originally arrested in this case on October 1st of 2024. He was arraigned on October 2nd of 2024 in the Willoughby Municipal Court. He was given a bond of $7,500 cash surety or 10% with scram, no driving, and no use of drug or alcohol. He bonded out on October 8th of 2024. His preliminary hearing was set for October 10th of 2024, which he failed to appear. A warrant issued on October 16th of 24, and bond was officially forfeited on October 29th of 2024. He was then arrested on his warrant April 23rd of 26. So that was 18 months that the warrant was out for. It would be his requirement to be in contact with his counsel during that time frame. I cannot say what he is indicating about notifications or anything of that nature, but if he thought the case was...
The opening hearing immediately shows how differently bond decisions are treated depending on risk rather than emotion. The judge wastes no time because the legal framework has already been established before anyone walks into the courtroom.
The case was over and it was months later for Scram to come. He should be in contact with his counsel to know. He could check the docket, but that warrant was out for 18 months and nobody located him in that time frame. This case was originally bound over as 2 felonies and multiple misdemeanors. He was indicted on 3 felonies and a misdemeanor, as well as he does have a prior criminal history of criminal convictions that go back to 2009. He also, during that time frame, has contempt of courts, other OVIs, obviously since this is a felony OVI, as well as probation violations in those cases. Based on all of that, we did feel the bond remaining revoked was appropriate. If this court is inclined to give him a bond, we do feel it should be a higher bond with a GPS as well, so we can be sure of where he is.
All right, the bond will remain revoked.
I'll see you in jail.
Hold on 1 second. Sir, Cochran, come on, sir. Hold on, sir. Yeah, just go ahead and go back and proceed there. All right, man, that's just all right.
All right, Ms. Himmeline.
Thank you, Your Honor. We are hearing case 26-CR-593, State of Ohio versus Isaiah McCoy. Present in court is a defendant who's accompanied by his attorney, Mr. William Watson. We are present today for an in-court arraignment on a 3-count indictment that was filed May 29th, 2026, and we are also present today for a change of plea. It is the state's understanding that the defendant is prepared to plead guilty to count 1, having weapons while under disability, a felony of the 3rd degree, with a voluntary forfeiture of all items seized. The remaining counts of the indictment would be dismissed at the time of sentencing.
Thank you. Mr. Watson.
Thank you, Your Honor. May it please the court, that is correct. That's my understanding of this morning's hearing. With regards to the arraignment, my client is in receipt of his indictment. We'll waive any service defects, any 24-hour notice, any reading of the indictment. Would like to enter a plea of not guilty to all the charges. And then, Your Honor, it is correct that after that not guilty plea is entered, my client wishes to proceed by entering a change of plea with a previously agreed upon plea deal with the state. My client understands that by entering a change of plea, he'll be waiving certain constitutional rights and no threats or promises have been made in order for him to do so, Your Honor.
All right, not guilty plea will be entered. And as to the, you said it was count 1?
Yes, Your Honor. It would be count 1, having weapons while under disability, a felony of the 3rd degree. State would dismiss counts 2 and 3 at the time of sentencing, and there is no agreement with regard to sentencing.
All right, thank you. Mr. McCoy, how old are you?
I'm 21.
How far did you go through school?
9th grade.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of this indictment?
Yes.
It's my understanding you're going to plead guilty to count 1, having weapons while under disability, of felony 3, and forfeit and the forfeiture specification, and then counts 2 and 3 would be dismissed at sentencing. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Watson some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
Jacob Cochran's hearing becomes a battle over credibility rather than innocence. His attorney presents missed communication as the central explanation, hoping the court views the failures as administrative instead of intentional. That strategy only works if the judge believes a reasonable person would stop asking questions after months of silence.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to count 1?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or to community control.
Yes.
Having weapons while under disability in count 1 is a felony of the 3rd degree. It carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification in count 1, you're voluntarily giving up any right you would have to the items listed. Do you understand that?
Yeah.
Are you presently on post-release control to the parole authority?
No.
Do you understand your felony conviction prevents you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
Ms. Himmeline, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on March 12, 2026, in the city of Willoughby Hills, Lake County, Ohio, the Willoughby Hills Police Department initiated a traffic stop on a vehicle traveling 102 miles per hour in a 65 mile per hour zone. The driver of that vehicle was identified as the defendant. The defendant's temporary driving permit was suspended at that time, and there was an odor of burnt and raw marijuana emanating from the vehicle. As a result, the police department searched the vehicle. They located a backpack inside the vehicle with the defendant's wallet, his state ID, and temporary permit, along with a loaded Canik TP9 SFX 9mm pistol, serial number 21BC 25555. The police obtained a search warrant for the defendant's DNA standard for comparison to the firearm. The firearm was sent to the Lake County Crime Lab for testing. It was determined to be an operable firearm, and the defendant's DNA was present on the firearm. The defendant does have a prior conviction for a felony offense of violence, and that is robbery out of Cuyahoga County Common Pleas Court, case number CR-24-691958-A, dated November 13th, 2024. Along with an accompanying SYO disposition in juvenile court, case number DL 241008888, dated January 13th, 2025. Thank you.
Thank you. Mr. Watson, anything to add to those facts?
No, Your Honor.
Mr. McCoy, did you hear what Ms. Himmeline said? The facts would show if the case went to a trial.
Yes.
Are those facts true?
Yes.
The lengthy constitutional rights discussion isn't repetitive paperwork. It's one of the strongest protections built into the criminal justice system. Every answer creates a record that becomes extremely difficult to challenge later. The judge isn't simply asking questions. Each question closes another possible avenue for appealing the plea based on misunderstanding or pressure.
What is your plea to count 1, having weapons while under disability, a felony 3?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
Mr. Watson?
This is the same paperwork we went over, so there's no changes to it. So, except you are a U.S. citizen, so you should just sign right there, but today's date. Today is 6/3/26.
Your Honor, I have the written plea of guilty and judgment entry that was signed by the defendant in open court. It was witnessed by myself and Mr.
Mr. McCoy, is this your signature on the written plea of guilty?
Yes, it is.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes, please.
I'll accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of his rights in a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of count 1, having weapons while under disability, of felony 3. I'll refer this for a pre-sentence report. Sentencing will be July 9 at 8 a.m. Mr. Watson?
Your Honor, thank you. May it please the court, if we could be heard on bond. There was a bond initially set in this matter out of Willoughby Municipal Court. My client at the time was homeless, so he missed his first preliminary hearing date. I actually filed a motion with Willoughby Municipal Court, explained the circumstances. Another preliminary hearing date was set. Again, due to his housing issues, we had trouble getting a hold of him to inform him of that date, so we missed that date. Bond was revoked. My client, I was able to get a hold of him. He knew there was a warrant out for him. He didn't run and hide. He turned himself in voluntarily, Your Honor. He does have a place to stay now. I'm respectfully asking the court, that particular bond has been revoked. It's gone, but I'm respectfully asking the court to consider either giving him an OR bond or granting him some reasonable monetary bond between now and sentencing. Thank you, Your Honor.
Similar?
Thank you, Your Honor. The state would ask that the bond remain revoked in addition to his failure to appear twice in Willoughby Municipal Court. The defendant, despite being 21 years of age, has a significant criminal history. He has multiple juvenile adjudications for assault and having weapons under disability. He has an aggravated trespass conviction from 2024 in Cuyahoga County. He also has a robbery conviction, as was set forth during the change of plea, for which he received a prison sentence and then a juvenile disposition. He does also have pending in Cuyahoga County Common Pleas Court another case for having weapons while under disability, and that was indicted in 2025, and that case is still pending before the court. Thank you.
All right, the bond will remain revoked.
All rise.
All right, I'll see you in the jail. Sentencing's up because of the July 4th holidays. It's July 9th, so it's basically a month.
The guilty plea becomes legally significant only after McCoy personally adopts the state's version of events. That admission carries more weight than many defendants realize because it removes factual disputes from the equation. Once the written plea and oral responses match, the court gains confidence that the decision reflects deliberate choice instead of confusion. The judge's findings emphasize intelligence, knowledge, and voluntariness because those three concepts form the foundation of any valid plea. Referring the case for a presentence investigation also signals that sentencing remains an open question. A guilty plea does not automatically predict leniency or severity. It simply changes what the court evaluates next. The conversation shifts away from proving the crime and toward measuring the individual behind it, including history, circumstances, and the likelihood of future compliance. The final bond argument exposes how dramatically perspective shapes courtroom advocacy. Defense counsel highlights homelessness and communication problems to portray missed appearances as instability rather than defiance. That narrative asks the judge to focus on changed circumstances instead of previous failures. The prosecution answers with a completely different framework. Instead of discussing hardship, it catalogs criminal history, pending charges, prior convictions, and repeated failures to appear. Those competing narratives reveal an important courtroom reality. Facts rarely speak for themselves. Lawyers organize identical histories into entirely different stories depending on their objective. One side argues rehabilitation and accountability. The other argues escalating public risk. Neither ignores the record. They simply assign different meanings to it. The judge's responsibility is deciding which interpretation better predicts future conduct, rather than rewarding the more persuasive presentation. The decision to keep the bond revoked reflects consistency more than severity. Earlier explanations, personal hardships, and requests for another opportunity ultimately fail because the court places greater value on demonstrated reliability than optimistic promises. Criminal courts routinely treat appearance history as one of the strongest predictors of future compliance, making repeated failures especially difficult to overcome. The judge's brief ruling carries more authority precisely because it follows a detailed record built throughout the hearing. Nothing suggests the outcome was impulsive. Instead, it reflects accumulated concerns that outweighed every argument for release. The closing scheduling remarks immediately return the courtroom to routine business, highlighting how quickly one defendant's future becomes another case on the docket. For the court, proceedings continue without pause. For the defendant, the consequences begin immediately.